Welcome to the online Domestic Violence Restraining Order workshop presented by the Sacramento Superior Court Self-Help Center. This is an informational workshop to help you understand the restraining order process and how to fill out and file your court forms. There are two parts to this workshop. In part one, we will talk about what domestic violence is and how a restraining order can help in domestic violence situations. We will also look at the types of restraining orders you can ask the court for, as well as other important orders you may want or need. In part two, we will take a closer look at the restraining order process, including the 5 essential steps you will need to take to get a restraining order. We will also look at the forms you will need to fill out and how. While we will not be going line by line through the forms, we will highlight some tips that are helpful to keep in mind when completing them. We will also explain important terminology, the purpose of certain forms, and tips for filling them out, including where to go for an online form completion program. Now let's start by talking about what domestic violence is. When many people think of domestic violence, they think of somebody hitting somebody else. But domestic violence is not just physical violence. It's also power and control over the other person. Domestic violence can involve using physical power to control the other person, but not always. There can be coercion, threats, and intimidation. It could be threats about you, someone you love, or a pet. Domestic violence can also be emotional abuse or verbal abuse. For example, it could be yelling or using demeaning language. It can also be isolation, keeping you from friends and family. The person may minimize, deny, or blame you after an incident of abuse. They may even use your children or pets against you. Domestic violence could also be economic abuse, where the abuser forces you to do things or they won't give you money to live. They may also keep the money away from you and restrict your access. Domestic abuse could also be sexual exploitation. As you can see, all of these things can be domestic violence. It is not just physical violence. Keep that in mind as you complete your forms and describe the past incidents of abuse. The goal in seeking a domestic violence restraining order is to break what we call the cycle of abuse. Because when domestic abuse happens, it typically follows a cycle. First, tensions increase, communication breaks down, and the victim becomes fearful. They may feel that if they please or satisfy the abuser and do what they want, they can avoid the trouble that is building. Those tensions build and build. Then there is an incident. As you saw, it could be verbal, emotional, or physical abuse. This period is marked by anger, blaming, threats, and intimidation. After the incident, there is the reconciliation period. Things get better. The abuser may apologize or give excuses. They may even blame the victim, or claim that it never happened, or claim that it was not as bad as the victim says. And then there's the calm. The incident is not talked about, and no abuse is taking place. Things are going all right, maybe even well. But then tensions rise again, and a new incident happens, and the cycle begins again. You may have overlooked past incidents of abuse because of periods of reconciliation and calm. But a restraining order is meant to break the cycle of abuse and stop the abuse from occurring again. Depending on the situation, there are several different types of restraining orders you can get. The first is an emergency protective order. This is issued when there is an incident and law enforcement comes out and assesses the situation and determines that protection is needed immediately. An emergency protective order is a short-term order to give you time to come down to the courthouse and get a regular restraining order in place. An emergency protective order generally only lasts up to 7 days. The other is a criminal protective order. This is issued by the district attorney. If the other party already has been convicted or is on probation for domestic violence or some other kind of violence, the district attorney can request a criminal protective order. You would be notified if you have either one of these. If you do have one of these, make sure that you attach a copy of it, or at least put down the case number on your request for a domestic violence restraining order. Even if you already have one of the first two types of restraining orders, you can still request a domestic violence restraining order. That is the type of restraining order that we are talking about in this workshop. It allows you to obtain additional orders for your safety and protection. To request a domestic violence restraining order, you will complete one packet of forms. it is a thick packet because there are 3 separate stages of asking the court for a restraining order. But all of the forms are combined and must be submitted at once. We mention this so that you do not get overwhelmed or confused when looking through the packet. But keep in mind, you will not need to complete all parts of all the forms. The forms you will find in the packet correspond to different stages in the restraining order process. The first stage is the request and notice of court hearing. In this stage, you are asking the court for orders and a hearing. The next stage is the temporary restraining order, which are orders granted to cover you until the hearing. Finally, there is the restraining order after hearing, which provides protection after the hearing takes place. All of these forms look very similar, so pay close attention as you fill them out. Pay careful attention to the sections that are for you to complete and those that the court must complete. For example, on the orders, the temporary restraining order and the restraining order after hearing, you will just fill out the top sections at the beginning of the orders. As we will discuss momentarily, if you are requesting other orders, you may also need to include things like names, addresses, and descriptions on each of these forms. However, do not check the boxes. The judge will check the boxes if the orders are granted. However, you will include descriptions and other information where needed. And in the request, check the boxes for the orders you are asking for. These orders not only include orders for your safety, like personal conduct and stay-away orders, but can also include orders to protect other parties, a move-out order, payment of monthly bills, and more. Let's go over a few of the different types of orders you can ask for as part of your request for a restraining order. An order you can request is a property order. For instance, if you are sharing a home, you can ask that the judge order the other party to move out. Just be sure to include the complete address in case you need to enforce the order. You can also ask for control of certain property, such as a car or a home, if the other party has already moved out. Again, be sure to include complete information, such as the year, make, and model of a car. There is even a special section for cell phones. For example, if you are on a family plan, you can request that the other party transfer the cell plan for your cell phone over to you, so that it is only in your name. You can also ask for the judge to order that the other party pay certain monthly bills, such as the mortgage payment or utilities. Even though they may have moved out, you can still ask them to pay the bills if it is necessary for you to stay in your home. Another thing that you can ask for is a support order, whether child support or spousal support. Keep in mind, you can only ask for spousal support if you are actually married to the other person. If the other person is your boyfriend or girlfriend, you cannot ask for spousal support. But if you have minor children together, you can ask for child support along with child custody orders. If you want to ask for support at the time of filing, you will need to fill out an income and expense declaration. That is Form FL-150. It is sometimes listed as an optional form because not everyone asks for support. When filling out the income and expense declaration, make sure to fill it out completely and attach your pay stubs or other proof of income. The Self-Help Center offers a workshop for assistance with this form. You can find more information online or contact the Self-Help Center through the court's e-correspondence system. A link to this system is shown here. Keep in mind, if you are only interested in getting the restraining order or getting the person away from you at this time, you can worry about the support later. You may also contact the Department of Child Support Services and ask them to get a child support order for you at any time. Child custody orders. As mentioned, if you have children together, you can ask for custody orders in the Domestic Violence Restraining Order request. There are two types of child custody. There is legal custody and physical custody. As we will explain, you can also ask for sole or joint custody for each. Legal custody is the right to make the decisions for the child. This includes where they will go to school, what doctor they will go to, or whether they have a medical procedure. You can ask for sole legal custody so that only you make the decisions. Or you can ask for joint legal custody where both you and the other parent can make these decisions. Physical custody is who the child lives with. It can be sole, or the child only lives with you, or joint, where they live with you part of the time and the other parent part of the time. If you are asking for child custody in Sacramento County, the court will send you to mediation, where a mediator will listen to both sides and make a recommendation to the court on what they believe is the best interest of the children. There can also be a child abduction order. The other parent can be ordered not to leave the county with the children. or not to leave the state. There are different options that you can choose if you are worried about them leaving with the children. Without this information, the court cannot make child custody or visitation orders. You can also ask for other orders in the request, like paying some or all of your lawyer's fees or attending a batterer's intervention program. There is even a specific section for pets. If you have pets together, you can ask for custody of those pets. Be sure to include both the name and physical description of each pet that you want included in your order. If you think of another order you would like, and there is not a corresponding checkbox, you can include that in the Other section to request it. Depending on the orders you are requesting, there are additional optional attachments that can be used to provide more information. Keep in mind, you will see similar attachments for the request, temporary restraining order, and restraining order after hearing. These attachments mirror each other, so do not be surprised when you see many forms that look the same or similar. But remember that you must complete the relevant sections for each of them and only check the boxes on the attachments to the request, not the orders. Now that we have gone over what domestic violence is, how a restraining order can help, and other types of orders you may want or need, let's take a look at steps in the restraining order process. It is helpful to understand how the whole process works so that you can be sure you follow the 5 essential steps for asking for a restraining order. These steps are: 1. Complete your forms. 2. File your forms. 3. Serve the other party. 4. File proof of service. And 5. Attend the hearing. There are also some things you may need to do after the hearing. We'll go over each of these one by one. The first step in the restraining order process is to complete your restraining order request forms. You have 2 options for completing the forms on your own. The first is to download the packet and fill it out line by line. There are direct links to packets on the restraining order page under the Departments tab on the court's website. Just make sure that you choose the correct packet, which depends on whether you have minor children with the restrained party or not. If downloading and filling out the forms packet, you can either type your forms on the computer or print them and fill them out by hand. Just make sure that if you fill them out by hand, you only print on one side of the paper. Also, print clearly in blue or black ink. Do not write in cursive. And as you complete the forms, make sure that you follow the instructions and read everything as you go. Your other option for completing the forms is to use Odyssey Guide and File. The Odyssey Guide and File is free, a web-based program that was developed in collaboration with the courts. Rather than completing the forms line by line, with Guide and File, you answer a series of questions, and the program completes the forms for you. A link to Guide and File is on the court's website and is also shown here. When you use Guide and File, you can save your forms as you go. The program also provides explanations of different terms. And if you answer all of the questions, your forms will be complete and ready for filing when you are finished. While you are not able to file your forms online through the Guide and File program in Sacramento County at this time, you can simply print out your completed forms and turn them in at the court. We will talk about how to do this in just a moment. When completing your forms, there are a few things to keep in mind. First, if you already have a family law case number with the court, and you are asking for a restraining order as part of that same case, use the case number that you already have for the family law case. For instance, you might already have a divorce case or a custody case open with the court. By using the same case number, you will have all the orders in the same case together for the judge to review. Next, be consistent in each form that you fill out. Use the same names throughout. Check that your dates are consistent each time you write them, and make sure your claims are consistent. Take your time in filling out the forms. If information is inconsistent, it could impact your case. Also, keep in mind that the other party, the party you are filing against, will see these forms. So take precautions if you are worried about safety. For instance, you must include your name and your mailing address on the court forms. But you do not have to use the address where you live. You can use a post office box instead. You can also use a work address, a friend's address, or any other address where you can reliably receive mail. And while you cannot leave the address section blank, you don't have to put a phone number. If you do decide to put a phone number, make sure that you feel safe doing so. Finally, if you fill the forms out on the computer, remember to save your work as you go, just in case something happens. The forms are long, so in case you need to finish them later, make sure that you save your progress so that you don't lose anything. Another thing to keep in mind when completing your forms is that in the request for domestic violence restraining order, you will be asked to describe the abuse. This is very important. The judge will decide whether to grant your temporary restraining order based entirely on what you include in your request. When describing the abuse, remember the following tips. First, start with the most recent abuse. Work your way back in time. Also, as mentioned earlier, consistency is very important, so make sure that you are consistent throughout your forms. Do not guess dates. If you're not sure, you can include your best estimate of when an incident occurred. Next, be very descriptive. Do not just say that the restrained party abused you. Instead, describe what they said and did. Use details. If you experienced verbal abuse, you can quote the words that they said, even if they used foul language. If you were hit, describe what they used to hit you, where you were hit, and if there were any injuries. If there were witnesses to the abuse, be sure to list them. The more details you include will provide a clearer picture to the judge of what happened. Just remember not to make legal conclusions in your descriptions. That is for the judge to do. Finally, if police were called, there are also sections to include that. The police may have provided you with a card or a brochure that includes the police report number. But even if you did not call the police, you can still include the incidents when describing the abuse. After you complete your forms, the next step is to file them. When you file your forms, there is a cover sheet to include on top as the first page. That is a very important document that the court uses for administrative reasons. If you use Guide and File, you will need to get the cover sheet separately from the court's website. It can be found in the DVRO forms packet online, which you can access by using the web link shown on the screen. While you may leave your phone number off your forms, it must be included on the cover sheet. This is the number that the court will use to contact you if necessary. The cover sheet will not be filed or provided to the other party. It is just for use by court staff. And if the court does need to contact you, the call will come from a blocked number. There will be no caller ID. Also, for safety reasons, the court will generally not leave a message for you. When it comes to filing, there are different options. The current options can be found on the court's website under the Civil Department's Filing Instructions and Procedures. You can also refer to the instructions included at the beginning of the packet and at the end of the Guide and File program. Then, when you submit your forms, you will be provided with instructions for how and when to pick them up. This information is also available on the court's website at the link shown here. It is your responsibility to pick up your documents as soon as possible. As we will discuss shortly, you will need to have them served on the restrained party before your hearing. You will not have a lot of time before the hearing and will need to make plans quickly. In general, if you submit your documents by 2 p.m., you will receive the results the same day and can pick up the filed documents at the courthouse before it closes at 5 p.m. If you file after 2 p.m., you will receive your results and can pick up your documents the next business day. The results refer to the judge's decision, which we will discuss next. After you have submitted your documents, the judge will determine whether to grant the orders you requested for the temporary restraining order. There are 3 possibilities. 1, your request may be entirely approved, meaning that all of the orders you request are granted. 2, your request may be approved in part, meaning that some of the orders are granted, but others are denied until the hearing. This could just mean that the judge needs more information to grant those requests. 3, your request may be denied, meaning that no orders would be granted before the hearing. Regardless of what the judge decides for your temporary restraining order, you will still have a hearing approximately 21 days later. Even if everything was denied, still go to the hearing. The judge just may need to ask you some questions and get more details. At the hearing, you will have the opportunity to present your reasons for why the restraining order should be granted. Please note that if your request for a temporary restraining order is granted, it is not enforceable until it is served on the other party. Law enforcement cannot enforce it unless it has been served on the other party and you have filed a proof of service. You can still report any incidents that occur, but they will not be treated as violations of the restraining order until it has been served on the other party. This takes us to the next step in the restraining order process, which is to serve the other party. Serving or service means notifying the other party in the proper legal way that there is a case against them, because the other party has a legal right to know about the case and respond. The judge cannot make any orders at the hearing unless service has been completed. So, Once you pick up your documents, the next step is to have the documents served on the restrained party. When serving your documents, there are different options. One option is to have the sheriff's department serve your documents for you. The link to their website is shown on the screen. The Sheriff's Department will serve your restraining order documents for free, but there are some limitations. First, the other party must live or work in Sacramento County. If they do not, you will need to contact the Sheriff's Department in the county where they live to have them serve your papers. Next, you must have an address where the other party can be served on a weekday during business hours. The sheriff will not locate the other party for you, and they do not serve documents on evenings or weekends. Finally, there is an instruction sheet that you will need to include with your documents. Be sure to include your contact information, the description of the restrained party, what they look like, and the address where they can be served. Also, if you wish to have the Sheriff's Department serve your documents for you, provide them with the documents as early as possible. Otherwise, they will not be able to serve them in time. You do not have to use the Sheriff's Department to serve your papers, though. There are other options as well. For instance, you can have your documents served by anyone other than yourself who is over the age of 18 and is not listed as a protected party on the restraining order. This can be a friend or family member. Another option is to hire a professional process server. A professional process server charges money, and the fees vary. But they may also be able to do more for you, like help locate a person, wait for the person if they are not at the location provided, or serve documents on evenings and weekends. If you need any of these services, this may be your best option. Whatever method you decide is up to you. Just remember that the server you choose must serve the documents to the restrained party. The restrained party does not need to accept the documents when they are handed to them. The server can place the documents at their feet if the other party refuses to take them. There just cannot be anything in the way. For example, if they are in the car, the window must be rolled down. If it is in a house and there is a screen door in the way, they have to open the screen door. There cannot be anything between them and the server. After the other party has been served, the next step is to file proof of service. This is a critical document that must be filed. The restraining orders are not enforceable, and the judge cannot make any orders at the hearing until you file the proof of service. The server is the one who fills out and signs the proof of service. By signing the form, they are stating, under penalty of perjury, that they served the restrained party. The person serving the court documents needs to be the one who completes and signs the proof of service. If you have the sheriff's department serve your documents, they will complete their own proof of service. They will also file it with the court, saving you that step. If you use your own server, you will have to make sure the proof of service is filed with the court. It is your responsibility to make sure that the proof of service is filed before your hearing. Without that form in your file, the judge cannot make any orders other than to continue the matter if the other party does not appear. The next step in the restraining order process is to attend your hearing. In fact, the temporary restraining order is called temporary because it only lasts until your hearing. At the hearing, the judge will decide whether to grant a long-term restraining order and for how long. You will need to make plans to appear for your hearing. Refer to the court's website for current information regarding how to appear for the hearing, which may be in person or through video. If the hearing is scheduled before you have completed service on the other party, still attend the hearing. At the hearing, you can ask to have the hearing rescheduled so that you have more time to have the restrained party served. This is also referred to as a continuance. If the judge grants your request, the temporary restraining order will generally be extended until the new hearing date. If you do not appear for your hearing, the matter will be dropped and the judge will make no orders. Then, if you still want to obtain a restraining order, you will need to refile all of the paperwork again. So it is very important to appear for your court hearing. When you go to your hearing, there are a few things to keep in mind. First, you are welcome to bring a support person with you. However, they cannot speak on your behalf. Only a private attorney can speak for you. The support person can just be by your side for emotional support. If you need an interpreter, one will be provided you by the court at no cost. Secondly, if the restrained party was served, they may appear at the hearing. The judge will then hear from each of you and decide whether to grant a restraining order. It could be granted for anywhere from a few months to up to several years. The length of the restraint period depends on the facts of your case and what you have requested. Finally, remember that there will be a number of people scheduled for hearings at the same time as yours. The hearing itself will generally last 15 minutes. However, your case may not be heard first, so plan accordingly. And if the restrained party appears at the hearing and there is a dispute, the matter may be set for trial at a later date. If that happens, the judge will still decide at the hearing what orders to make until the trial date. After the hearing, if the judge grants your long-term restraining order, court staff will tell you how to pick up the restraining order after hearing. If it is not given to you at the court, then you will need to pick up the actual physical copies at the courthouse, but a copy will also be posted online. To get a copy of the court order or any mediation reports online, go to the Public Case Access System at the address shown on the screen. You will have to enroll before you can access them. The enrollment form is in the restraining order packet. Just make sure that you photocopy your ID to attach to the form and clearly print your email address so it will be entered correctly. When court orders or mediation reports are posted, you can access them for free for 72 hours from when they were posted. After the 72 hours, it will cost money to access the orders or reports again. During that free 72 hours, make sure that you download or print your court order in case you need it again. The restraining order after hearing may also need to be served on the restrained party. It depends on whether the restrained party appeared at the hearing and what orders were made. The restraining order will have a section that indicates whether and how it needs to be served. If it does need to be served, follow the instructions and then file a proof of service with the court. Otherwise, law enforcement cannot enforce it. Keep extra copies of the restraining order and the proof of service in all important places, such as your home, work, and in your vehicle. Give a copy to anybody who may need a copy, such as your daycare provider. The reason for this is that you will always want to have a copy of the restraining order with you wherever you are, in case the other party shows up and violates the restraining order, and you need to call law enforcement. The restraining order will also be uploaded to law enforcement's online system. They will be able to see the restraining order and proof of service once it has been filed. However, it is still best to keep a physical copy with you in case you need to provide this proof. In closing, we hope this online workshop has helped you understand the restraining order process and how to fill out and file your forms. Keep in mind that the court's website also has a lot of information on this and other topics. Additionally, any changes in court services will be posted on the website. When navigating the website, click on the court seal in the upper left corner, which will take you back to the home screen. There is also a search bar in the upper right corner that you can use to search for key words. On the same page as this video, we have included the most relevant and helpful links for restraining orders. For example, you can find restraining order packets, how to request the sheriff's department to serve your documents, how to request an interpreter, and how to contact the Self-Help Center for further assistance. For links to forms, questions about next steps, or questions about other family law issues, you can also contact the Self-Help Center through the e-correspondence system. Thank you.